Good afternoon, everyone, and welcome to today's webinar. I'm Sophie Miles. I'm a barrister and mediator at Doughty Street Chambers, and it's my pleasure today to introduce and chair the second session of our series of talks on stress at work. You're going to be hearing from four excellent speakers. I'm not going to take up any of your time by talking about them because you can see from the slide who they are and you can find out a little bit about it. The plan is for each speaker to talk for between 10 and 15 minutes, and that should leave us 10 to 15 minutes at the end for questions. You'll see that there is a question and answer spot for the questions to go in. Please, could you put your questions in the Q&A box, and we'll come to them at the end of the speeches. So without any further ado, I'm very pleased to hand over to Finian Clark, who's our first speaker.
Thanks, Sophie, and good afternoon, everyone. Great to have you join us. I'm going to start by giving a brief overview of how today's webinar is going to play out. As mentioned by Sophie, this is the second seminar or webinar, part of our series on stress at work. And this one is dealing specifically with the questions surrounding concurrent claims in separate jurisdictions, namely when you have claims in both the Employment Tribunal and the county or high courts. I'm going to begin by briefly recapping on our first seminar, just to get everyone up to speed if you weren't able to attend that one. That seminar dealt more broadly with the comparative merits of bringing claims in the ET in civil jurisdictions. And then I'm going to talk about one of the key issues you've got when you've got concurrent proceedings, two proceedings going on at once. That is the principles and the mechanics of getting a stay. Mine is just going to be an introduction really to those concepts. Then I'm going to hand over to Frederick, who's going to take you through the res judicata principles and consider when it is that one proceeding is debarred because of findings or arguments made in another set of proceedings. And then Paras and Matthew are going to deal with these questions in a slightly more practical way by going through some worked examples. And then we'll, as Sophie mentioned, we'll go into the Q&A. Next slide, please. So just to briefly recap on where we got to last time, stress at work claims, as I'm sure everyone here will be familiar with, can come in the form of employment tribunal claims, principally through discrimination or whistleblowing causes of action, not limited to that, but those usually how personal injury claims arise in the ET context, or they can come in the form of civil claims, usually based on tort, negligence, or sometimes harassment. So there is an extent to which we can forum shop, and that's what the first seminar was dealing with. If you've got a discrimination claim leading to injury, you may well also have a negligence claim, but to a large extent, the courts are only going to let you deal with that question once. So you've got to think about which is more appropriate. And I'm not going to go through the table on the slide here in great detail. That was something discussed in the first seminar, but this summarized the relative drawbacks and merits of going to each jurisdiction. So next slide, please. Dealing with stays when you've got concurrent proceedings, some general background. Parties can apply to stay one set of proceedings in order to make progress in another and to give precedence to another, or a court can do this of its own motion. Briefly, the powers that govern this, there's no special rule per se. In the ET context, it's just your general powers of general case management under Rule 29 in accordance with the overriding objective. And the same is true in the civil context. There's the power to state proceedings set out in CPR Rule 3.12F. The question that a court is going to consider is essentially whether the essentially the same issue is being run in two separate proceedings, and if so, there should be a stay. And the question that we're going to be grappling with in the next few minutes is which proceedings should be stayed. In the High Court context, it's worth noting that the court can go further than an employment tribunal. The High Court can order that an employee stays their ET proceedings via a mandatory injunction, as that case at the bottom of the slide there, Corian and Lane, dealt with. That is something, as held in the Mindy Maxnox judgment, which we'll come to, that an employment tribunal can't do. They can't order that you stay your high court proceedings. So there's a bit of asymmetry there. And as we go through the case law, we'll see that there is that asymmetry plays out and permeates these principles. And there is a general precedence for high court proceedings. We'll come on to how that differs in the county court proceedings shortly. Next slide, please. So the leading case, certainly in the employment context here, is the Mindy Maxnox case. This is a case involving a claimant bringing claims for unfair dismissal and a wages claim in the employment tribunal based on a failure to pay them a bonus. And the respondents then bring separate high court proceedings dealing essentially with the same issue. And the respondent applies for a stay of the ET proceedings. The claimants make clear in this case that really what they want is speedy resolution of their dispute. So they want to go to the employment tribunal, although employment practitioners amongst us will be surprised to hear that that employment tribunal proceedings are characterized as being speedy here. But this is, so the way that the EAT deals with this is to reject the kind of primary submission made by the respondent that there is a general primacy of the High Court, and the High Court deals with complex matters, whereas the ET doesn't. That's rejected in quite strong terms, that employment tribunals are perfectly capable of dealing with complex matters. And at paragraph 29, the EAT says it's a question of balance. But the factors that are pointed towards are set out on your slide here. Generally speaking, where there's a very substantial factual dispute, the proceedings are more appropriately to be brought in the High Court. If findings, and this is an important part that we'll come on to when we're thinking about the county courts, where findings are made by the employment tribunal, and those would bind the High Court by virtue of res judicata, which Frederick's going to talk about later, that can be embarrassing for the High Court, to use the words of the EAT. So that is, if there's going to be a question of res judicata, it's more appropriate that the High Court has dealt with that issue than the employment tribunal. Another factor that's pointed towards in Mindy Maxnox is with the complexity of the issues, but again, that's deprecated as being a sort of not being a general principle. And also in the remedy, the size of the remedy. In that case, they estimated that the employment tribunal claim was worth about 1% of the High Court proceedings because of the statutory cap in unfair dismissal cases. So the starting point in that case is that the employment tribunal proceedings will usually be stayed behind the High Court, and that was applied in that case. Next slide, please. There are a number of exceptions to this. I'll whiz through them because I'm conscious of the time, but broadly, in the case of Langford, which we've got here on the slide, in that case, the employment tribunal first instance proceedings had actually already been concluded, and the EAT had held that then parts of that judgment had to be reopened, reconsidered. And at that stage, High Court proceedings were issued. And because of how advanced the employment tribunal proceedings were, it was held that they should be dealt with because of that point about speediness. Vaughan is another relevant case where here the overlap was held to be fairly limited, namely that the ET claim was actually much more extensive. It dealt with wide points about discrimination that could only really be resolved before the employment tribunal. And so the fact that peripheral issues could overlap with the High Court issue meant that the ET claim should continue. And there's this point that I've touched on a couple of times at paragraph 42, where it's held that Parliament should generally be taken to intend that employment tribunal proceedings are dealt with speedily. Next slide, please. Next slide, please. Thanks. So this is quite a short and neat point there. The Halstead case makes clear that the general precedence in the Mindy Maxnox factors for High Court proceedings to go first doesn't apply when High Court proceedings haven't yet been issued, perhaps intuitively so. So where in that case where there'd been a letter before action for the High Court proceedings, but no claim issued, at that point there was no need for an employment tribunal proceeding to be stayed. I won't go into much detail on that. So next slide, please. Lycatel is a recent case dealing with these issues and deals with some of the skirmishes that you might see in practice when these sorts of cases are litigated. One argument and one skirmish that played out was that because the two proceedings here were identical, namely a contract dispute over the claimant's bonus payment, that in effect what the court should do is just abide by that individual's choice of forum. And that was rejected. That's not the only consideration where someone has chosen to go to. In the first instance, there are all the Mindy-Max-Knox factors to apply, and that's rejected at paragraph 56, where the EAT notes there's no right to bring a claim in a particular forum. Secondly, relatedly, an argument that was dismissed was that the respondent, by bringing subsequent proceedings in the High Court, was essentially trying to dictate forum. And in that case, at paragraph 62, the EAT held that if it's genuinely considered that the High Court was the more appropriate forum, then that sort of argument can't hold any sway. Next slide, please. This is my last slide, and perhaps this is the sort of thing, the practical questions that are going to play out in more detail in Paris and Matthew's presentation. So I won't take much more of your time, but just you've got those on the slide, the sort of considerations you might consider about which procedure, which court should be preferred, and which one a stay is likely to be given in. And just touching briefly, thinking about how the Mindy-Max-Knox principles might be altered in the county court context. Well, would there be the same issue about the High Court being embarrassed by findings of the Employment Tribunal in the county court? Probably not. We wouldn't think that a finding binding, an ET finding binding the county court would embarrass the county court in perhaps the same way. Would the county court be better equipped to deal with complex issues? Well, I think it depends on those particular issues. If we're dealing with negligence leading to injury, then perhaps the county court is better equipped with those arguments. But if the claim is more oriented around discrimination, then perhaps not. So it depends. I've rattled through a lot of points there, but I'll hand over to Frederick, who's going to deal with res judicata.
Thanks, Finn. There's two values broadly which justify the recognition of res judicata principles and estoppels. The first is that it's in the public interest that there should be an end to litigation. And the second is that people shouldn't be vexed twice in the same matter. And the lines between traditional res judicata principles and the wider doctrines that we're going to look at, and the related issue around abuse of process, are often indistinct. And in practice, it's not always necessary to identify with clarity which doctrine is being invoked. It's common to find cases being argued and often decided on the basis that if one doctrine does not apply, then another certainly does. And the place we're going to begin, if we turn to the next slide, is with the Supreme Court decision in Virgin Atlantic Airways, where Lord Sumption stated the modern law, and he said that res judicata is a portmanteau term which is used to describe a number of different legal principles from different origins, and that, as with legal expressions, the label tends to distract from attention from the contents of the bottle. He separates or distinguishes four types, four strands to the res judicata piece, and we're going to look at the first of these, which is cause of action estoppel. On the next slide. So cause of action estoppel stops a party from challenging the same cause of action that has been the subject of a judicial decision in earlier proceedings involving the same parties or their privies. And importantly, neither cause of action estoppel nor issue estoppel, which we're going to come to in a moment, is limited to cases where the Employment Tribunal has given a reasoned decision on the merits. So a procedural decision or even an unreasoned decision would also stop you from challenging the same cause of action, related cause of action in subsequent proceedings. Can we have the next slide, please? The next strand identified by Lord Sumption in the Virgin Atlantic case was merger. And this is where a cause of action is extinguished once a judgment has been given on it. It's a rule of law which is rigid in that there's no room for exercise of discretion. And an example of this came up in a case called Fraser, where the claimant had brought a wrongful dismissal claim in the employment tribunal, which was subject to the £25,000 cost cap, and then tried to claim the excess damages in the High Court, and they were prevented from doing so. If we go to the next slide, one of the things that the Fraser case tells us is that even where the claimant in that case had expressly reserved the right to bring High Court proceedings for that excess in their wrongful dismissal damages over the £25,000 cap, the High Court prevented them from bringing that claim. So that's something to be wary of. And I think the practical advice which flows from that is that claimants probably shouldn't be including wrongful dismissal claims within employment tribunal proceedings for unlawful dismissal unless they are willing to limit their damages for the former to £25,000. So in some cases, this may not arise, but in others, that's something that needs to be considered carefully. The exception, obviously, to this is that if the two causes of action are different on a careful analysis, then obviously both can be run in different fora. And the Botham case shows that in terms of a breach of contract claim being different from the statutory regime on costs in the employment tribunal. Can we go to the next slide, please? The next strand is issue estoppel. This prevents a party from reopening an issue that was decided in earlier proceedings involving the same parties if it's necessarily common to both proceedings. And that phrase necessarily common is significant. And the example of Green is involved where there was an unsuccessful earlier unfair dismissal claims which precluded the High Court action seeking declaration the dismissals were ultra vires and void because the employment tribunal had previously found that claimants had been dismissed and there had been no unfairness in that process. On the next slide, we see that where the employment tribunal has rejected a race discrimination claim on limitation grounds without considering any relevant issues, the issue estoppel did not apply in a subsequent High Court claim for negligence and breach of contract regarding the same psychiatric injury. So in some cases where you've got a discrete, essentially procedural issue, it may be possible to run the point. It's interesting that this was applied in the context of limitation, which is a mixed question of fact and law. But in that case, it was felt that these were essentially severable issues, and the court hadn't considered the issue sufficiently that they couldn't litigate the breach of contract and negligence claim. Can we look at the next slide, please? So in the Virgin Atlantic claim, the Supreme Court said in terms of the scope of these estoppels that the cause of action estoppel is absolute in relation to all points which were and had to be decided. And the cause of action estoppel also bars in subsequent proceedings raising points which are essential to the cause of action which were not raised in earlier proceedings if they could have been raised with reasonable diligence. And on the next slide, we see that in the case of issue estoppel, there are potentially exceptions to that where there are special circumstances where injustice would result. And issue estoppel also prevents someone from raising in subsequent proceedings points that weren't raised in previous proceedings if they could have been raised with reasonable diligence. Next slide, please. Abuse of process. This is a linked concept which traditionally precludes a party from raising in subsequent proceedings matters which were not, but could and should have been raised in the earlier proceedings. And the Henderson and Henderson cases is the classic authority on this. The modern approach is that the courts will adopt a broad-based merits judgment. They'll take into account the facts of the case and the public and private interests involved. And the crucial question is essentially whether a party is misusing or abusing the process of the court. And the courts don't tend to get too hung up on exactly on the kind of legal niceties, but they're more interested in a holistic view about whether someone is essentially misusing the system. Can we have the next slide, please? The case of University of London is an example of subsequent High Court proceedings not being an abusive process after a failed discrimination and successful victimization claims in the ET. And the success or failure of the earlier employment tribunal claims didn't turn on the contractual entitlement point that was raised in the High Court proceedings. And so the proceedings were deemed not to be abusive simply because the remedy that was sought was the same as for the discrimination claim. And in that case, the findings of fact from the employment tribunal were relied upon and could be relied upon. And that did not in itself render the second proceedings to be abusive. So that's an example of the limitation of the abusive process point. Could we have the next slide, please? The dismissal of an employment tribunal claim following the claimant's withdrawal did preclude a second claim as it was caught by the cause of action estoppel and/or abusive process. That was a case where the court said, well, if it wasn't cause of action estoppel, then it would be an abusive process. In the Staffordshire case, under the Employment Tribunal's 2004, that outcome was avoided where the claimant reserved the right to bring civil proceedings when withdrawing from the ET claim, and there was case law on that. On the next slide, we can see that under the 2013 rules, where a claim is withdrawn, the ET shall issue a judgment dismissing it, which means that the claimant can't commence a further claim against the same respondent, raising the same or substantially the same complaint, unless they've expressly reserved at the time of withdrawal the right to bring the further claim, and the tribunal is satisfied that there would be a legitimate reason for doing so, or the tribunal believes that this wouldn't be to issue that judgment wouldn't be in the interest of justice. So there is some scope under the 2013 rules to deal with that point, but the tribunal essentially has a discretion, quite a broad discretion, it could be argued, to take a view about whether it's appropriate for that point to be dealt with following a withdrawal. So that's something to be careful of when withdrawing in these situations. Next slide, please. A compromise of discrimination and harassment claims, which involve paying in full and final settlement of all claims against the claimant's employers arising out of their employment, being claims in respect of which an employment tribunal has jurisdiction, did render the subsequent negligence action for personal injuries regarding the same incident as an abusive process, as that loss could have been claimed in the ET. So that's a case where those instructed initially, the court said, should have, with reasonable diligence, have brought all of those points together in the employment tribunal, and it was too late to do it after the fact, even though on a kind of cause of action analysis they were different. And there's a recent example there we've cited of Ake. I think that's my final slide. Can we just check? It is. Thank you very much. And I'm now going to hand over to Paris.
Thank you, Frederick. Good evening, everyone. I will be building upon Finian and Frederick's whistle-stop tour of staying proceedings and res judicata principles, and speaking to you all about a case study that's loosely based on a matter which I've recently had involvement with, which involves the application of some of the principles that we've covered today against the backdrop of whistleblowing and concurrent High Court proceedings. And if we move to a couple of slides in, turning to the facts of the case study, In brief, the claimants in this case were a married couple who were ordinarily resident and nationals of Syria. The first claimant was recruited to the respondent to work as an IT systems manager, whereas the second claimant, who was in fact his wife, was recruited to work as an export assistant. Both of the claimants were sponsored by the respondent for work visas, and the respondent had the ability to effectively revoke those visas at will. They lived in rented accommodation, and the second claimant was, at the material time of these events, pregnant with the first child. The claimants also have extended family in Syria. Now, the respondent's business is ostensibly in relation to the supply resale of chemical products worldwide, and the owner-director of the business has significant connections in Syria. The claimants contended that the unofficial business of the respondent was the supply and resale of chemical products to Syria. We move to the next slide, please. Now, during their employment, the second claimant informed her husband that the respondent's export manager, who was a line manager, had criticized her for questioning the propriety of an export license for a shipment of chemical products which were destined for an address in Syria. The export manager had informed the second claimant that she would be informing the director of the respondent about the matter and about her raising these issues. And about a week later, the second claimant again informs the first claimant that she had been asked to alter the description of some goods destined for Syria, so that it accorded with the export license. Now, at this point, the first claimant begins to share the second claimant's concerns about what's going on and starts doing some investigation over these matters. Both of the claimants raise these issues with the export manager and rely on the information that they convey as protected disclosures. We move to the next slide, please. The export manager brushes the concerns raised by the claimants away, and the second claimant informs her manager she will not carry out any further instructions because she believes they're unlawful, and escalates her concerns to the director of the respondent, who's the majority shareholder. Now, the director and the second claimant speak over the phone, as he's overseas at the time, and has a conversation in which it is acknowledged by him that the second claimant has made a disclosure and has raised concerns about the propriety of the shipments. Towards the end of the call, the director reminds her to keep quiet about this issue, and that if she continues to raise these issues, there will be consequences. The director comes back to the UK about a week later after his trip to Syria. We go to the next slide. What we see is feeling troubled and concerned about what's going on and the discussions with the director, the second claimant in the intervening period decides to raise what are known as third-party protected disclosures, both to the police and the Office for Financial Sanctions Implementation, as well as HMRC, and urges them to investigate the respondent's activities. One day after the director returns to the UK, he asks both of the claimants for their passports and confiscates them on the pretense that the Home Office wish to check their documentation due to their immigration status. The next day, both of the claimants are asked to attend a meeting with the director after work. No details are given to them about what the meeting is about, and the claimants presume it's innocuous in nature. We go to the next slide, please. At the end of the day, after their shifts, when all the other staff have left, the director and another individual separate the two claimants and take the second claimant, who's heavily pregnant at this time, into a separate room which is locked. At this point, the director begins to threaten the first claimant and asks for all of his IT login passwords, and asks him to speak to a police officer on the phone, who starts to ask a number of personal and inappropriate questions. Now, at this time, the first claimant starts to protest at his treatment and is directly threatened by the director and another individual, who tell him to answer the questions posed to him on the phone that are being asked, otherwise his baby and wife will be at risk. The director also threatens harm to the claimant's family in Syria and informs him that he knows where they live. Go to the next slide, please. Under duress, the first claimant agrees to speak to the individual on this phone, and once the call is concluded, he's informed by the director that he believes both of the claimants have stolen a sum in excess of £400,000 from the respondent by double invoicing for materials and or setting up fictitious limited companies, effectively passing the funds through these companies. And at this point, the first claimant is repeatedly threatened again, as is his wife and their unborn baby. The first claimant under duress is asked to log into his own personal bank account and transfer a sum of circa £35,000 to the bank account operated by the respondent. Now, as he's making these transfers, luckily his bank intervene and stop further transfers due to fraud checks. And so he manages to retain some funds in his bank account. Once it's apparent to the director that the first claimant's unable to transfer any further monies on the internet banking system, the director informs him that both he and his wife are summarily dismissed as of that date. We go to the next slide. So those are the factual, relevant factual matters in this case study. And in terms of proceedings, what happens after dismissal is soon after it, the respondent applies for an ex parte freezing order, which is granted by the High Court and is extended to the worldwide accounts held by the claimants on the return date until the end of proceedings. And about 4 weeks later, the respondent files and serves particulars of claim, and shortly thereafter amended particulars of claim, alleging fraud, conspiracy, misrepresentation, breach of fiduciary duty, as well as a litany of other claims, accusing effectively both claimants of diverting at least £400,000, but asking for a search order and an account of profits because they believe the sum may actually be much higher. Go to the next slide. Now, the claimants file a defence in due course and deny any wrongdoing to the claims and facts asserted by the respondent, and allege that any circumvention of funds were effectively done on the express instruction of the director of the respondent, and that all invoices and payments were either authorised by him or his head of finance. Furthermore, and this is where things start to get a little murkier, the claimants contend that the legal action, that's the High Court proceedings that they face, as well as the dismissals, were a direct result of protected disclosures made by them in relation to what they perceive to be unlawful activity by the respondent, in effect intermingling their whistleblowing as their defence to the High Court proceedings. Go to the next slide, please. Now, the consequence, and we move on to their proceedings, but the consequence of the granting of the freezing order means that the claimants have restricted funds for both their ordinary living expenses and for seeking legal advice. However, fortunately for them, they had the benefit of legal expenses insurance through their home insurance for bringing employment tribunal proceedings. And so protective claims were issued on their behalf. For those of you who are employment lawyers will be familiar, automatic unfair dismissal due to protected disclosure, and also detriment due to protected disclosures, as well as various discrimination claims. Now, it's around this point where I become involved, and I have a conference with those instructing me, as well as the first claimant. And as a result of that, the claims are amended and clarified, and an application to amend the original ET1s is filed with the Employment Tribunal. Now, what the respondent does is file a defence to the tribunal claim and seek a stay of proceedings pending an application they are making for summary judgment and or conclusion of High Court proceedings. A significant factor which the respondent relies upon is the fact that there are extant High Court proceedings which commenced earlier than the tribunal claim. Go to the next slide. Tactically, from the claimant's perspective, they're anxious to have their employment tribunal claim heard first, as they believe it will exonerate them completely and will strengthen their defence to High Court proceedings. In particular, the claimants believe that if their whistleblowing claims are determined in their favour, that will weigh heavily in the High Court action because of the intermingling of the whistleblowing protected disclosures with their defence. Now, the tribunal decides to list a preliminary hearing to determine whether proceedings should be stayed upon the application of the respondent. Now, you might be guessing which way the wind's blowing here, and so I'll put you out of your suspense as to what the tribunal did. The tribunal decided to grant the stay, and the Mindy-Max-Knox factors that Finian has discussed earlier on in today's presentation came into play here. If we go to the next slide, you'll see a number of the factors which Finian's touched upon, dealing with the first complexity of the factual matters. It's fair to say both of the claims appear to be complex, but it's probably fair to say that the High Court proceedings involved a tangled web of forensic financial data, which appeared to tip the balance on this factor in favour of the respondent, as well as the multiple causes of action advanced against the claimants. In relation to the embarrassment factor to the High Court, this was potentially problematic because, of course, if the Employment Tribunal determined findings of fact in relation to both the disclosures as well as associated factual matters, it could have bound the High Court on overlapping subject matter, especially, as I say, because they were intermingling their defence to the High Court proceedings with their whistleblowing allegations. And so, again, that tipped the favour on that factor to the respondent. In relation to the third factor, complexity of legal matters, my personal view, not that the judge accepted it, was that I thought this was a neutral factor, given the complexity of the tribunal proceedings. However, the tribunal was swayed in relation to this because there were allegations of fraud, obviously, of course, made in relation to the High Court proceedings. And so that factor also went for the respondent. In relation to the extent of overlap, analysing the pleadings, because of the intermingling, there was a considerable overlap between the proceedings. And so, against the balance tipped in favour of the respondents. Again, you'll probably follow on the comparative value of the claims. Whilst, of course, whistleblowing dismissal claims are uncapped and can be potentially high value, given the quantum of the High Court proceedings and the money at stake, that again tipped the balance for the respondent in seeking and obtaining a stay. I've made reference in the last bullet point of the slide to what would occur if High Court action was merely threatened and not extant, as it was in this case. And of course, Finian's touched upon the case law in Halstead and Payment Shield, which made clear that there's no presumption of a stay where High Court proceedings have been threatened. But of course, in practical terms, the tribunal will still have adherence to the Mindy-Maxnox factors. We turn to the final slide. The impact on the ET proceedings. Now, just generally, because of the stay, of course, there'll be a lengthy delay in the adjudication of the tribunal proceedings and a risk of staleness in respect of the matter because of the stay, which will have a knock-on effect, of course, on the evidence. And given the nature of the whistleblowing claims before the tribunal, it was going to be heavily predicated on the credibility of the claimants on the one hand, and of course, the director for the respondents on the other. The other issue, of course, is with the High Court proceedings being adjudicated upon, any substantive win for the respondent would have effectively caused a whole heap of issue estoppel arguments that would have been run in the ET, which might have had a potential to dispose of the entire employment tribunal proceedings, depending on the outcome of the High Court proceedings. And finally, of course, given the allegations against the claimants, there's a real prospect of criminal proceedings to follow, which would have obviously impaired or impacted the ability of the tribunal to adjudicate upon that matter. So that's my final slide. It's just to effectively give a taster of the type of issues which can arise from an employment perspective when dealing with concurrent claims in the tribunal and High Court. I think my colleague Matthew now will be running through a couple of case studies dealing with issues from a personal injury perspective. Over to you, Matthew.
Thanks, Paris. Yeah, that's right. I'm going to now be looking at a couple of PI case studies, which I'm afraid are nowhere near as exciting or dramatic as Paris's case study, which I felt at some moments was about to kind of turn into a James Bond movie. So if we go to my first slide, please. Case study number one, like Paris's, this is sort of semi-fictional, but they're both based on a couple of my cases, with tweaks here and there. So what have we got here? We've got a claimant who's an inspector for a government agency, and she's raised some issues with occupational health about back pain that she's been experiencing whilst traveling and generally, and so goes to occupational health, and they advise that she should try to reduce the number of off-site visits that she's doing and find ways, if possible, for her to join meetings via technology, as we're doing right now. Her line manager agrees to try the one-to-one meetings remotely, but doesn't really do much about the in-person meetings and inspections she needs to go to, but suggests maybe she get a disabled badge for traveling. She then goes on a particular date, on a particular visit, and is standing for a long time on a train with a heavy bag and suffers a back injury. So go to the next slide, please. Those were the facts, fairly straightforward. What happened procedurally? She starts by bringing her claim in the Employment Tribunal, alleging failure to make reasonable adjustments, Section 21 of the Equality Act. I don't know much about employment law and how all of this works, but the case goes through the Employment Tribunal. They unanimously dismiss all of the claims. She tries to appeal it, but that's refused. Then tries to bring a PI claim in the county court for negligence and breach of statutory duty in relation to the very same issues. So that's when I kind of get involved. Next slide, please. Referring back to the legal principles that Freddie went through earlier, and those different species of res judicata at the 4 strands. I'm only going to look at 3 of them that apply here, but let's go through them in turn. The first one was cause of action estoppel. So is this a cause of action estoppel case? No, because the cause of action in the PI claim is negligence in common law and breach of statutory duty, whereas the cause of action in the Employment Tribunal claim was obviously different. It was Section 21 of the Equality Act. Okay, there's a bit of overlap in terms of breach of statutory duty, but they're totally different bases. The breach of statutory duty in the PI claim is the various regulations emanating from the Health and Safety at Work Act, not the Equality Act. So it's a no to cause of action estoppel. What about issue estoppel? So go to the next slide, please. This, you'll recall from Freddie's overview, is not about whether it's the same cause of action, but whether the underlying issues are the same. Is this issue estoppel? Yes, it looks like it. You need to, well, we need to carefully look at the factual matters which underpin the PI claim that we're facing now, or that we're bringing now, and ask, are they the same as those which underpinned the Employment Tribunal claim? And you can, I mean, you might be able to do that by even comparing the particulars side by side, which we could do in this case. And it was clear that the factual ingredients were the same. Both sets of particulars had the same factual ingredients. The claimant had a long-standing back condition. The defendant was aware of this. She'd been assessed by occupational health. Occupational health had made those recommendations that she should be allowed to attend via technology. And then she was required to go to a particular meeting in person on a certain date and had that back injury on the train. Those facts are simple and narrow and straightforward, and they were the facts in both. So on that basis, it looks like issue estoppel, but it goes even further, because actually on these facts, not only is the claim being brought based on the same issues, but this was adjudicated by the Employment Tribunal. The Employment Tribunal had considered that claim and dismissed it, along with a number of other claims. So issue estoppel, yes. Let's move to the next slide, please. Then there's the other strand, abuse of process, different from estoppels, but related, Henderson and Henderson abuse of process. Is this also an abuse of process as well as issue estoppel? That is less straightforward, but the answer is probably. it's not the case that automatically it would be an abusive process, because like Freddie was saying earlier, the court has a discretion here, and what they do is take a holistic approach and do that broad, or exercise that broad merits-based judgment. So it's not automatic, but it seems to me on the current case law that the starting point is probably that it will be an abusive process unless there's a special reason. I think the best way to look at these is to start by asking, to start by working out whether there's a special reason why a PI claim could be brought afterwards. And really, the only example that arises from the cases that I can see that would amount to that special reason is if the full extent of the injuries were not clear at the time of the employment tribunal proceedings, but have come to light later. And you might get that in the kind of cases we do with psychiatric injury. It wouldn't be that uncommon. But asking that question here on these facts, the answer was no. It was a physical injury. It happened on the day. There's nothing to suggest that the claimant wasn't aware of the full extent of her physical injury when she brought those employment tribunal proceedings. So it doesn't look like there's a special reason, but still the court needs to do this broad merits-based judgment. And the components of a broad merits-based judgment were set out by Lord Bingham in the case of Johnson and Gore Wood. And he said that the judges need to take account of three things: public and private interests, all of the relevant facts of the case, and then thirdly need to focus their attention on the crucial question of whether in all the circumstances a party is misusing or abusing the court process. Next slide, please. So applying those quickly here, public and private interests, it's generally in the public interest for all claims arising out of the same facts to be dealt with in the same proceedings. That's in the interest of justice. It's also important for the efficient use of court resources. So that points in the direction of it being an abusive process to allow the second bite of the cherry. It's also in the public interest to prevent repeat or relitigation. Whilst it's definitely clearly important that an employee, a claimant, should be able to bring their claim and have their claim determined by a court, if they've had the opportunity to do that, it's also important that employers and defendants are not subject to, maybe it's a bit dramatic to call it this, but harassment through the courts. There's the principle of finality too, which points in the direction of it being an abusive process. And I suppose there's a question about whether there might be forensic prejudice at all in between the employment tribunal proceedings and the PI claim. Also, so those are public and private interests taken into account. They point in the direction of it being an abusive process. Also, all of the facts of the case need to be taken into account. In this case, it means looking at the reasons why the claimant didn't bring the PI claim as part of, well, in fact, it did here, but if a PI element wasn't brought as part of the employment tribunal claim, asking why, the question why, and working that out, but also looking at what happened in the employment tribunal proceedings and what was decided if it did go to be disposed of by the tribunal. Comes down to this key focused question, though, of is the claimant abusing the court process? And the answer in this case is probably yes. So that's case study number one. Now let's look at case study number two. It's also not very James Bondy, I'm afraid, but it's a nurse case, which I do quite a lot of. Here we've got a senior community healthcare nurse in the NHS. Long and distinguished career in community healthcare. The service, unfortunately, is then privatized the local clinical commissioning group ends up handing out the contract to a private company. Surprise, surprise, privatization does what privatization does. Staff numbers are cut. There's an increase in workload for the staff. Concerns start to arise about patient safety. And sorry, am I running out of time? Sophie.
Got about 10 minutes before 6, so it's 9 minutes to 6.
Okay.
So we have got a couple of questions. Not very many.
I'll pause.
So go on.
I've got this second case study, but let me pause. It might be that it gets dealt with in the questions. If not, the slides are there, and people can look at it afterwards.
Okay. Right. Thanks very much. I mean, thank you, all of you. Really interesting and informative talks. We've got a question that I'm going to put to Finian in the first instance, and it arises from the case study that Paris told us about. So the question is this: what if the High Court proceedings reach a conclusion and they're adverse to the two claimants? How would the question of res judicata then play out in the employment proceedings?
Interesting. So I suppose taking that in stages, I've got to confess I'm not as familiar with Paris's case as he is, but I'll have a go at summarizing the issues. The first question, I suppose, is cause of action estoppel. And there wouldn't be, I would expect, a cause of action estoppel issue. The causes of action in the High Court, I think Paris was saying, were things like fraud, misrepresentation, breach of fiduciary duties. Those, I would imagine, are fairly obviously conceptually distinct from the detriment and dismissal on the grounds of protected disclosure, causes of action raised in the employment tribunal. So there wouldn't be an issue there. But I would imagine that the claimants in the employment tribunal would come into difficulties with the issue estoppel question. The Paris's clients were raising whistleblowing as part of their defense to the High Court proceedings, effectively, which means that the High Court will determine, to some extent at least, the whistleblowing question, the causation between their protected disclosures and the nasty outcomes and the transfers of money and all the rest of it. So in that case, those findings, if they're adverse in the High Court, would be binding on the employment tribunal. And there's also the question of credibility. You'd imagine that a High Court case like that would determine, would make findings on their credibility, or it's at least possible. And so should they try and relitigate that question in the employment tribunal and say we make a positive argument that we do have credibility and our account should be accepted, that issue again may be stopped pursuant to issue estoppel. So in short, it may be pretty tricky for them.
I can see Paris nodding. Is there anything you want to add to that, Paris?
No, Finian, that was a great synopsis of the issues that would arise. I think the only thing I would say is, in terms of credibility, that given the employment tribunal proceedings were entirely based on what each party said, obviously a High Court finding or adverse finding against the claimants as to their illegal activities and or activities in relation to the financial side of things would obviously have a knock-on effect as to their credibility in the ET proceedings, as to whether these disclosures that they made caused any of the detriments. So I agree with Finian's synopsis effectively. Really, we're looking at issue estoppel here as opposed to cause of action, because the causes of action in the employment tribunal and the High Court proceedings are entirely distinct. But given the commonalities, a binding decision on the High Court would effectively tie the tribunal's hands in any later litigation.
Thank you. Thanks both very much. So we've now got a question arising from Matthew, your case study. And the question is this: in relation to case study 1, would the analysis be different if the ET had not determined the Equality Act claim by the time that the PI claim was issued?
Okay, that's a perfect question, because that's sort of what I was coming on to with the second case study.
Excellent.
Let me deal with it though much more pithily than I was going through all those slides, because there's a lot there. It depends what would have happened. What I was about to look at is other things can happen. The employment tribunal case could get compromised by a settlement agreement, and if that happens, then the key question is whether that settlement agreement includes either expressly within it wording to say that the PI case can continue afterwards, or words to that effect. And even if it doesn't, there are cases where the courts have construed the parties as having assumed that, and there being a common assumption that that was the case. And in both of those circumstances where there's that settlement agreement, either the contractual interpretation of that settlement agreement will preclude the respondent from raising abuse of process down the line in the PI claim, or there will be a estoppel by convention because of that common assumption, which prevents the respondent from arguing abuse of process down the line. That's if there's a settlement agreement. Another scenario, though, might be that it's simply withdrawn without a settlement agreement. If that happens, the principles are sort of similar in that it all turns on whether what the claimant did was an abandonment of an acceptance that the claim would fail on the merits. So in withdrawing, it would be important. I mean, Paras and Finian will know how to do this much better than I do, but basically in withdrawing, it would be important in the cover letter or the email to set out that this is not an acceptance that the claim would fail on the merits, and we're preserving the right to bring a PI claim down the line. And I've set out suggested wording in both of those scenarios in my slides.
Okay. Thank you. I'm just going to ask if anyone's got anything further that they want to add to that answer. We've just got a couple more minutes. So if any of the rest of you have any thoughts, please do say.
Just a general point, given we're talking about stress at work claims here, obviously the more obvious overlap between claims which might give rise to cause of action estoppel or issue estoppel in the PI context are effectively disability discrimination claims, particularly those predicated on a mental impairment being advanced before the employment tribunal. And one common one is obviously stress claims, both as a disability and a self-standing personal injury claim. Obviously, we've got about 2 minutes left, but if you take anything away from this talk, it's just to be very, very careful about the limits on which your proceedings in the employment tribunal and or high court proceedings proceed, particularly where there's overlapping causes of action and subject matter as well as quantum. One of the things we haven't touched upon, and that's because it's going to be covered in our next webinar seminar, is on quantum and the effect of proceeding in both forums, both in the ET and civil courts, on the recoverability of damages. So keep an eye out for that in due course.
Okay. Thank you. And I think that brings us pretty neatly to 1 minute to 6. I don't see any other questions. So I think what we will do is, oh, there is one. There is one more question that's just popped in. Should we give that a try in 1 minute? Can one bring a PI claim in a case where the employment tribunal claim has been struck out due to mental health issues? Anything any of you want to say about that in 1 minute?
Perhaps it'd be helpful to clarify, struck out due to mental health issues. What does that entail? As in the conduct of the claimant or something has led to a strikeout or something like that. Yes, I see. Well, reasoning that through, I don't imagine that would give rise to to cause of action or issue estoppel questions, because that question hasn't been determined. The strikeout has been on the basis of conduct. So in that case, I don't think that would be too problematic. I suppose it would be potentially a broader abuse of process point, depending on the facts and the similarity between the two, and if the latter court, the PI court, effectively felt they were litigating an issue again when they'd been struck out for their poor conduct. But it would depend on the overlap between those two cases, I would imagine.
Thank you, and I can see Paris nodding approvingly to that answer. Thank you for dealing with that so quickly, Finian. That's great. I think that does bring us to a close, and I just want to thank everyone for attending and the speakers for their presentations, and to remind you that there is a third session, which I believe is on the 20th of September. And I think, Ray, there may be a slide with some information that we could perhaps pop up just so that the listeners can see that. But as Paris said, that is on quantum, 20th of September. And I've got no doubt that invitations will be going out shortly. Here we are. There, it's save the date on the 20th of September. So thank you all very much indeed for attending. I hope you found it very, very informative and enjoyable, and I wish you all a very good evening. Thanks a lot. Bye-bye, everyone.